Chapter 7 bankruptcy is the type of bankruptcy that most people think about when they hear the word bankruptcy. It's called a liquidation bankruptcy. Sometimes it's termed straight bankruptcy, even though that's not part of the Bankruptcy Code's definition for it. A liquidation bankruptcy very simply says if you have any assets that aren't protected under exemption laws, and we'll talk about exemption laws in another video, if you have anything that's not protected under the exemption laws, the trustee that's assigned to your case by the court will assert control over those assets. They will sell them either to you or to somebody else and take the proceeds or the money that comes from those sales and distribute those proceeds out to your creditors. This process usually takes about 6 months to complete on an average. Something you need to understand is very rarely are there cases where the trustee really thinks that there's something to be distributed unless you've got a tax refund coming in or unless you have some sort of a recreational assets or something that's just non-exempt. Now, timing becomes real important because tax refunds come in and can be spent and then aren't an asset that's available for distribution in your Chapter 7 bankruptcy estate. The process of a Chapter 7 I mentioned is about 6 months. Once the paperwork is all prepared and it's filed with the court, the judge will issue an automatic stay that tells your creditors they have to back off. They can't garnish, they can't levy, they can't seize property, they can't sue you. Now, there are exceptions to the automatic stay. For example, child support and alimony payments can continue to collect even in spite of a bankruptcy filing. But your credit card collectors have to back off. There's a hearing that you have to attend about 5 weeks after we file the bankruptcy. It's called a meeting of creditors. Your trustee in bankruptcy will expect you to send information to his or her office to help them kind of verify the information that was submitted with your paperwork. They'll want to see copies of bank statements and pay stubs and car titles, tax returns, this type of stuff. You attend the meeting of creditors. It's a very straightforward hearing. Don't lose any sleep over it. Someone from my office will be present with you at that hearing. It will probably be me. Now, after that hearing, creditors have 2 months, 60 days, to file a complaint for non-dischargeability. And I'm talking about the types of debts that are dischargeable, debts for potentially for credit card bills and debts for false representations and debts that they're alleging that you've done something improper. I'm not talking about child support, alimony payments, most student loans, most taxes. These are going to survive the bankruptcy anyway, usually. Once the 60 days have expired, then the clerk of the court is going to issue a discharge, and it's going to be an 8.5 by 11 sheet of paper. You know, it's not going to have that many words on it, but it's going to say you are now discharged from all your dischargeable debts. If you have any questions about what that discharge means, please feel free to schedule up an appointment to meet with me in my office, and I'll explain to you what has been discharged and what has not at the close of your proceedings.